The U.S. Supreme Court's annual summer break gives us a chance to look back at key developments during its last term and a chance to look ahead to the new term that starts in October. Joining us with expert analysis is Ilya Shapiro. He is vice president of the libertarian Cato Institute, director of Cato's Robert A. Levy Center for Constitutional Studies, and publisher of the Cato Supreme Court Review. Welcome back, Ilya.
Good to be with you, Mitch. It's an annual pleasure.
We always start off with this, and I know you usually say, well, you shouldn't try to look for a key theme from an entire Supreme Court term. But if you're looking back at the Supreme Court, was there a key theme or a general impression about the cases of the past year?
Well, I guess it's defying expectations would be the theme. I mean, this was the term that was supposed to be the coming out party for the new 6-3 hyper-partisan, hyper-conservative Supreme Court. And despite the last day's high-profile cases that did break on such so-called partisan lines that we can get into, the term was really marked by surprising unanimity and never before seen splits and alignments. There just weren't too many ideological-looking decisions, though that's partly because the more pragmatic justices forged grand compromises.
We're going to get back to that final day and the 6-3 rulings in just a bit. But first, other key rulings that drew your attention during the course of the term.
Sure. The case that was supposed to be the biggest one of the term was Fulton versus City of Philadelphia, where Philly revoked the participation of Catholic Social Services from its adoption and foster program that had been involved in for 150 years because it would not place with same-sex couples. No same-sex couples were actually denied a foster placement. Nothing had changed. But still, this action developed. And at the end of the day, this ended up being a unanimous ruling against Philadelphia because it turned out that there was discretion for a city bureaucrat to make exemptions from this anti-discrimination policy. And therefore, the court held through the pen of Chief Justice Roberts that this wasn't truly a generally applicable rule, that the Catholic Social Services wasn't treated equally to everyone else. Reminiscent of Masterpiece Cake Shop, the case a few years ago where the baker in Colorado, there was found to be anti-religious animus. So they didn't squarely decide what people think of as the supposed conflict between anti-discrimination law and the First Amendment.
Yeah, so that was a big one. Others that really attracted your attention?
Sure. The student speech case, biggest one in probably 50 years, the potty mouth cheerleader, as some are calling it, Mahanoy School District versus BL. BL was a minor at the time, Brandy Levy. She's now gotten publicity for this case. A cheerleader who, when she was 15, did not make the varsity squad, was upset about this. Express some profanity over Snapchat. Back in my day, we would just get together with friends and express frustration. But these days, it all gets broadcast into the ether. And even though Snapchat is supposed to disappear after a few seconds, we know that nothing is only temporary on the internet these days. And anyway, a coach heard about this. She was suspended for a year from cheerleading at all. Made a case about it, and the court ruled 8-1 that indeed the school district overreached. They didn't make a blanket rule that schools did not have regulatory authority outside the schoolhouse gate, off campus, not during school time. But it's a pretty high bar that administrators really need to reach. Death threats or other significant impairments of orderly educational activities. And that was an opinion written by Justice Breyer at a time when people started talking about, well, maybe this is actually the Breyer court now. That was an important and interesting case.
You mentioned a little bit earlier that on the last day of the term, there were two 6-3 rulings that some might say fit with what has been sort of the standard rule of a conservative wing versus a liberal wing. What did you make of those two rulings that were very important that came out on the last day?
So first of all, just to be clear on the stats overall, there were 55 cases decided after argument, which was very low, the second lowest since the Civil War. The lowest was the previous year in the teeth of the pandemic. But of those 55, only 12 came down 6-3, and only 6 of those 12 were in the so-called expected conservatives versus liberals lineup. And of the 5-4 rulings, there were 6 of those. That was in 5 different alignments. So again, a lot of flux, not a lot of this, supposed ideological split. But 2 of those that were the Republican appointees over the Democratic appointees were on the last day. One was the election law case out of Arizona, Brnovich versus Democratic National Committee. A lot of voting rights activists didn't want the DNC to bring this case because it challenged provisions that were quite commonplace across the country. The rule that you have to vote in your own precinct, and that there's no ballot harvesting. That is, only members of your family, caretakers, the postman, and election workers can touch a mailed-in absentee ballot. But more important than those actual provisions, which the Biden administration agreed should survive review, was that this was the first time the court was taking up Voting Rights Act Section 2 claim, that is, vote denial based on race, in a context other than redistricting. So this sets the standard going forward for challenges, be it voter ID, changing the number of early voting hours, handling of mail-in ballots, et cetera, that's now very much in the news as different states codify and change their rules, standardize their rules post-COVID. It's an unfortunate accentuation, I think, of the voting wars when there's really neither systemic fraud nor suppression going on. The other case that was decided 6-3 was on donor disclosure. California had a rather unusual law requiring all charities. Now, this is an important point, not political campaigns. It's not a campaign finance regulation, but all charities to disclose their donor information to the Attorney General, ostensibly to be able to police fraud. And this has only been enforced for the last 10 years or so, starting with when Kamala Harris was the state AG, then Javier Becerra. It's changed names as different California AGs joined the Biden administration. But anyway, odd bedfellows supporting the challenge to this law from the very left to the very right, from completely non-political, non-ideological organizations of various kinds, just charities, again. And so perhaps not surprising, but disappointing that this broke down on so-called ideological lines when everyone from Planned Parenthood to the ACLU to Cato and again, completely non-ideological charities were joining in that challenge. But the court did rule that administrative convenience was not enough of a state interest to require this sensitive disclosure that could chill speech and association. After all, like 50 years ago, 60 years ago, when the Attorney General of Alabama wanted the donor lists of the NAACP. So similarly here in our polarized time, when there's a lot of chilling of speech or wanting to affect how people go about their freedom of association, that there's no need, again, to have this information immediately. If you suspect fraud, fine, go about your investigation, your subpoena, et cetera. So those were the big last day rulings.
People can read Cato's Supreme Court review to get more on these and the other cases that were decided during the course of the term. I want to turn now briefly to a couple of the individual justices. This was the first term for Amy Coney Barrett. What was your take on her?
Yeah, those who thought that she was appointed to take healthcare away from millions of people were either misinformed or disingenuous, because the Obamacare case, that was probably the very last existential challenge. We'll still be litigating different aspects of healthcare regulation for a long, long time, but this is probably the last chance to knock out the whole law. And the court ruled 7-2 that the states and individuals who were challenging it didn't even have standing, and she joined the majority there. She ruled according to her own brand of jurisprudence, was very much in the middle of the court. I think she was second only to Brett Kavanaugh as being the justice most often in the majority. But the first term of any new justice is always, they keep their head low. They try not to make waves. This was certainly the case here. She only wrote 4 majority opinions. I don't know whether she lost a majority along the way, but in any event, she did not make big news with what she wrote. A little bit more on what people call the shadow docket. That is not the cases that are taken up and fully briefed and fully argued and decided, but emergency appeals, death penalty motions, that sort of thing, especially on pandemic-related restrictions where Justice Ginsburg, whom she replaced, was voting to sustain these state restrictions. Now the court started going 5-4 the other way and enjoining them. But we'll see in coming years as kind of the coalitions coalesce, as it were. And I think there's much more difference attitudinally than substantively. Some people talked about a 3-3-3 court with the left, the right, and kind of the middle or the center right, and the middle being Roberts, Kavanaugh, and Barrett, but much more attitudinally how far and how fast they're ready to go rather than the actual decisions on what's constitutional or not.
The other particular justice I want to talk about, you've already referenced him, Stephen Breyer. We've seen some pressure from left-wing activists for Justice Breyer to retire so the Democrats could have another appointee. At the same time, you've already mentioned it. Some have been saying that this has been Stephen Breyer's most influential time on the court.
Yeah, I mean, you can understand why he doesn't want to leave. For one thing, the Democrats still have their Senate majority at least through next year's midterm, so he doesn't see an urgency to retire this year. He is at the height of his powers, of his influence. He's 82, turning 83 later this month, August of 2021, but seems to be in great health. And this was his first year that he is the senior most liberal justice. He was in the shadow of John Paul Stevens and Ruth Bader Ginsburg, and finally he gets his moment in the sun. And I think that's why he wants to be there. So, the pressure from activists at the margins probably, led him to stay on another year even more, because he doesn't want to see the court be seen as politicized. He gave a lecture at Harvard in April talking about how the court is a legal institution, not a political one. And you see that in the various unorthodox alignments of the justices. Indeed, this term we talked about, maybe it's the Thomas Court as the senior most conservative, as it were, the senior most associate justice. Then it became the Breyer Court, as he wrote some important opinions, the Obamacare case, California versus Texas, the student speech case, as I mentioned, crafting coalitions with Roberts and Kavanaugh. Then maybe it's the Roberts Court after all, and now maybe it's the Kavanaugh Court because he was in the majority in all but 2 cases this term. So very much a court in flux.
Well, as the court is in flux now, let's take an opportunity to look ahead. Obviously, the court will be back in October. We know a number of the cases that it will be taking up. What are you going to be looking at when the court resumes its work?
Well, the 2 highest profile cases clearly on the docket involve the Second Amendment and abortion. The court hasn't pronounced on the scope of the right to keep and bear arms since announcing that individual right in 2008 in the District of Columbia versus Heller case. 2 years later, they extended that right to the states, but again, didn't define it. So, here we are, 13, going to be 14 years by the time they decide this case out of New York about the right to carry and how lower courts should be evaluating Second Amendment claims, because there's been, they've been going every which way, judicial resistance, if you will, to the right. So that's going to be obviously a high profile case. And abortion, a case out of Mississippi that asks whether any pre-viability restrictions are valid, and indeed reevaluating the standard, like under the Second Amendment. How should lower courts look at abortion cases? The reigning law is not Roe versus Wade. Roe established the right to abortion, but the rubric for evaluating them is the so-called undue burden standard from Planned Parenthood versus Casey, 1992. Again, going to be 30 years. I think that Casey standard, which people joke has for a long time meant a restriction that gave Anthony Kennedy a headache. Well, now maybe they'll go back to Roe's trimester rubric. Maybe there'll be some sort of scrutiny level at different point in some trimester. Who knows? But obviously, Mississippi filed its brief and several amici asking for Roe to be overturned altogether. I highly doubt they're going to do that in that case, but I do think that Casey's undue burden standard will be changed.
These and other cases will, of course, generate headlines during the course of the coming year, starting with that new term in October. We know that one person who is going to be following it very closely and perhaps will join us again next summer to tell us how it all turned out, is Ilya Shapiro. He is vice president of the Cato Institute, director of the Robert A. Levy Center for Constitutional Studies, and publisher of the Cato Supreme Court Review. Thanks so much for joining us.
Thanks for thanks for having me, Mitch. And if people want to dig deeper into some of the political dynamics underlying all of these machinations and future appointments, my still timely book, Supreme Disorder: Judicial Nominations in the Politics of America's Highest Court, still available wherever fine and not so fine books are sold.